Oyez, oyez, oyez. All persons having business before the Honorable, the United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Be seated, please. Case number 24-3151. United States of America versus Garrick D. Richardson, appellant. Ms. Millian for the appellant, Mr. Glasser for the appellate.
Good morning, Ms. Millian, whenever you're ready.
Good morning, Your Honors, and may it please the court. Courtney Millian on behalf of Mr. Richardson. I'd like to reserve 3 minutes for rebuttal. 18 USC 922 G1 disarms Mr. Richardson based on his 2 prior carrying a pistol without a license convictions. Carrying a pistol without a license is not a crime, much less a felony in most states in the union. Notwithstanding this fact, the government claims he can be disarmed consistent with the Second Amendment under 922 G1. It is wrong. I'd like to focus my argument on Mr. Richardson's as-applied challenge, though of course I welcome the court's questions on the facial challenge to the extent it has them. Bruin and Rahimi make clear that the burden rests with the government to demonstrate a sufficiently robust enough historical tradition to justify its modern firearm regulation. To do so, it must point to a historical tradition that shares both a comparable burden and that is comparably justified. The government has failed to meet that burden here.
Why doesn't Medina take care of this aspect of the analysis?
So Medina is both, has been overruled by Bruin and Rahimi and is distinguishable. I'm happy to discuss either of those.
It seemed to hold that 922 G1 is consistent with the history and tradition of firearms regulation in this country.
So I don't think it did so, or certainly did not do so using the test set out in Bruin and Rahimi, and thus has been overruled. The challenge brought by the plaintiff in that case was this argument that only dangerous felons could be disarmed under 922 G1. It was an as-applied challenge, and the court erred in several ways, and in ways that are fundamentally inconsistent with the reasoning of Bruin and Rahimi, and thus mean the decision's been overruled. First and foremost, it erred in placing the burden on the plaintiff to demonstrate.
Well, I'd like to understand better why you think that it's inconsistent with Bruin and Rahimi, because it did not use a means-ends balancing test, which seems to be the main thing that was definitely overruled by Bruin and Rahimi. And the type of analysis it did seems quite consistent with what Bruin is asking for.
So part of what Bruin did certainly was overrule means-ends balancing, but that's not all it did. It made clear that the burden rests with the government to demonstrate that historical burden, and that's repeated again quite clearly in Rahimi. And in that particular respect, the court fundamentally erred in Medina by placing the burden on the plaintiff.
How did it place the burden on the plaintiff?
It talks about how the plaintiff's sources do not compel the conclusion that only dangerous persons can be disarmed, but it was not the plaintiff's burden to cite sources that compel the conclusion. It was the government's burden. So in that respect, and that's fundamentally core to the court's reasoning, it gets that wrong. It also mentions sort of the absence of primary sources on point. Again, that is used as evidence in Bruin and Rahimi, particularly Bruin, for the idea that this is not the kind of thing that can justify disarmament. The court gets that wrong. It relies on the virtuous citizen principle, which was clearly overruled in Rahimi. I mean, it actually even overruled a watered down version called the responsible citizen test that the government had attempted to invoke. It also relies on this concept that dangerousness is too amorphous, which again is wrong.
There are aspects of Medina that it turns out are problematic, to be sure. The placement of the burden, the reference to virtuous citizens. But when you look at the decision writ large, it's doing history and tradition. And after the statement about the burden of proof, it addresses history and tradition and goes through all the tradition of, the tradition is felons can have all their stuff taken away and be executed.
So it certainly relies on this death concept, which is probably the only piece of it that I think wasn't overruled or clearly overruled. The problem is that's just a single piece of the court's overall reasoning and not the only thing it's hanging its hat on. And when we have, I mean, I've cited precedent.
Pretty important.
It is
I mean, the
important.
virtuous citizen thing is an afterthought.
So I don't read it as an afterthought. But I would also just note, I mean, I also think Medina is distinguishable because it did not consider whether felons whose priors, modern day felons whose priors have no founding era analog would not have been punished with death at the founding. It does not answer the question because the parties never asked it to. There's not part of what was briefed. It never answered the question of whether death can justify their disarmament. And it can't hear that death-based set of reasoning actually supports Mr. Richardson's as applied challenge because his prior offense, carrying a pistol without a license, has no founding era analog, would not even have been a crime at the founding, much less one punished by death.
If you look at as applied, if you look at the circumstances of Mr. Medina versus Mr. Richardson, I'm not sure that's a very favorable comparison for you.
So, I mean, I think it is an analysis that's properly confined to Mr.
I
Richardson.
mean, if the question is, is the felony kind of more malum in prohibitum regulatory, is the offense, is the person not dangerous or violent? I mean, Medina was less obviously violent than Richardson, at least according to the indictment.
So there's a lot in that, and I want to unpack it in a couple of stages. First of all, I think Medina's prior felony, which was lying on a mortgage application, he was accused of fraud. People were put to death for fraud at the founding. People were not put to death for carrying a pistol without a license or for anything analogous. And the government hasn't claimed that they were. On the as applied
versus the conduct that was charged here.
So if you look at
it's not the world's most serious offense, but the conduct is very serious.
So the conduct surrounding
Out in a garage in a nightclub, guy gets shot. He's involved in that.
So a couple of things there. The as applied analysis, I mean, the conduct in the parking garage, which I repeat are allegations, Mr. Richardson never admitted to them. That conduct is not properly part of an as applied analysis because an as applied analysis, what disarms Mr. Richardson and why 922G1 applies to him is because of his prior carrying a pistol without a license convictions. It is not because of that conduct, which, to be clear, if the government had thought indeed happened and it could have proved, it was more than welcome to charge. That other information, I mean, he's not disarmed because of any alleged attempted threats, assault or anything. That's simply not what 922G1 is doing. And that's a choice Congress made. And that's a choice about how Congress wrote that statute.
What about the fact that he's on supervised release?
So
He's still serving a sentence for one of those, right?
So again, I just don't think that's relevant to an as applied analysis under 922G1. 922G1 references a term of imprisonment. It's not talking about supervised release. Now, supervised release would be relevant.
Applied to your client. And if he's somebody who's on supervised release, it seems that he's the kind of person that could be disarmed. Other circuits have held so.
So I think we would be in a different world if this was a supervised revocation proceeding and we were challenging, Mr. Richardson's revocation under supervised release. That's not where we are.
Other cases, because I guess there are at least 3 other circuits that have held that it's constitutionally applied to people who are on supervised release.
So that's right. And I think those circuits get it wrong. And I would just note, first of all, that the Third Circuit, which is one of the courts that has been doing this, has actually recently taken a couple of cases en banc and specifically asked them to brief this question of what facts can be considered in a as applied analysis under 922G1. So I think there may well be, though,
Well, do you have any
time will
precedent
tell.
to support your position that this is not properly taken into account?
They don't, but But I think it follows
I'm asking
from,
you, do you have any precedent to support your position that you're taking before us that we can't consider the fact that he's on supervised release?
so I think it follows from, I don't have a case right now, but I think it follows from the Supreme Court's decision in Rahimi and the way it has understood as applied analyses in other contexts. If you look at the court's decision in Rahimi, it chronicles a whole bunch of very serious conduct by Mr. Rahimi in the background section of its brief. But when it came time to do the as applied analysis, and to be clear, it repeatedly calls it as applied to Mr. Rahimi, it confined itself to what was relevant to the statute's application under 922 G8. And in particular, the finding that would have been made by a judge. And I think that exactly models the proper analysis here. We're not looking at extraneous facts that have nothing to do why Mr. Richardson was disarmed under 922 G1. And, similarly, we cite a number of, and the amicus brief in support of our case cites a number of other Supreme Court decisions, like Eichmann, for example, where the Supreme Court recognized that someone who had burned a flag and caused damage to government property could be prosecuted under a property damage statute that made that property damage relevant,
Your
but could not
position then
be.
is what we can consider as applied to him, specific to him, is the fact that his prior convictions were CPWL.
Yes,
But we can't consider the fact that he's still serving the sentence of one of those CPWL convictions.
correct, because that's not what 922 G1 disarms him based on. And I would
It
also
seems like
just,
that's a fact that's intertwined with us considering that he's been convicted of CPWL.
respectfully, I don't think so, because that's not what's triggered his disarmament under 922 G1. It's the fact of the conviction, not the sentence. And I would separately note, it's not clear to me, quite frankly, what was going on with the supervised release. As we know, there is indication in the record he likely was on supervised release, but there's also this statement in the PSR that Mr. Richardson successfully completed his supervised release. And I think that at least raises the question on this record about, whether he was on supervised release, or at least, whether the terms of his supervised release prevented him from having this firearm.
Sorry, why can't we even consider the fact that he's on supervised release?
Because that's not,
Applied challenge?
because that's not why he's been disarmed under 922 G1. It's just not what has caused him to be disarmed. Whether or not he was on supervised release is irrelevant.
But the as applied rule that you're advocating is some form of, you look at the facts and circumstances and assess the individual, right? You looked at dangerousness, you looked at criminal conduct. Why would we not consider that?
So the type of test I'm advocating for is one that that follows the model that the Supreme Court set out in Rahimi and confines itself to what is relevant to 922 G1's application, just like the Supreme Court confined itself to what was relevant to 922 G8's application.
Although there was a court order,
What?
there was a court order in Rahimi, correct?
Yes.
And here there's a court-ordered supervised release.
Sure, but that 922 G8 disarmed him based on Mr. Rahimi, based on the existence of the court order. That was like part of what the statute was doing.
And
That is not,
and the supervised release, did it not provide that he was to remain unarmed for the period of his supervision?
it's not clear to me on this record that it
Suppose it
did.
did, then what?
I still think we prevail because, that would be entirely relevant to a revocation of supervised release. And,
Right, but
if we were in that
but
posture, I would.
We're here now, not in supervised release, but not in a revocation proceeding. So he's under assume he's under a court order that prohibits him from having a gun while he's under supervised release. How is that any different than Rahimi for
the reasons I said, which is that 922 G8 made that court order relevant. And Rahimi, that's, the statute that Congress wrote. That's simply not what Congress did in 922 G1. It's not a supervised release disarmament
Suppose he was
statute.
still in prison then?
He'd be guilty of violating a law that had to do with
He's in prison. He manages to obtain a weapon, which happens from time to time.
I mean, again, there, I would think, first of all, that's a different circumstance because at least there, 922G1 is talking about imprisonment, but I still think then, he needs to be prosecuted.
It doesn't say imprisonment. It doesn't any more than it says under a court order.
But
It just says felony conviction.
I'm not sure that's quite right, but setting that aside, I mean, I think the way to make that legally relevant is to prosecute, whoever it is under a statute prohibiting someone from having firearms in prison. No one's saying these can't, that's not a crime. It just needs, if the government wants to stand up and argue that someone can be disarmed based on these facts that are totally extraneous to the charge that it has brought and the injury that it has caused, it needs to actually charge that conduct. And there are plenty of laws that it could have used here and could have made these types of things relevant. But there's a reason it didn't do so. In my estimation, it's because it didn't think it could prove that.
So it seems to me that I thought that an as-applied challenge just required us to look at whether the law is constitutional as applied to this individual. So we would be then allowed to look at the facts and circumstances of this individual. And since this individual is on supervised release, then it's constitutional to disarm him because people who are still serving their sentences shouldn't have firearms. And then that's consistent with what 3 other circuits have held. And it seemed consistent with lots of things like public safety concerns, et cetera. You're saying even if it's true that he shouldn't have a firearm based on his individual circumstances of being on supervised release, even if that's true, I can't consider it. And I shouldn't consider it. And to me, that seems very technical. And I think what you're asking for is for us to consider the same individual in several different, I guess, there would have to be several different cases against him. Like we'd have to wait until they move to revoke his supervised release or something in order to consider the fact that he was on supervised release. Like how would we be able to consider this relevant fact?
I think exactly what you said, which is that they would move to, I mean, they could have charged Mr. Richardson with the assault if they thought they could prove he committed assault. They could have charged Mr. Richardson with the Glock switch if they thought that they could prove that he knowingly had.
So even if the facts are in the record and there, and even if you like assume for the sake of argument that you concede that the fact that he's on supervised release would be an appropriate and constitutional basis to disarm him, we cannot consider that basis unless it's charged. Is that it?
That's right. I mean, how I think of an as-applied challenge based on things like City of Los Angeles versus Patel, which talks about what it means. That was a facial case, but it talks about what it means for a statute to apply and for its application to be relevant.
Then you're defining constitutional rights based on charging decisions or a mistake by the government in missing a charging decision. And I don't, do you have any precedent for that kind of highly technical and granular analysis to assess a constitutional right based on, I guess, charging decisions like that, even if the facts are there?
I mean, I've referenced it already, which is the Supreme Court's decision in
But just because
Rahimi.
they did it that way doesn't mean it's required. If they do it that way in one case, doesn't mean that's a requirement.
I mean, I think it modeled the appropriate analysis. And I think particularly when you look at some of the other cases we've cited outside of the Second Amendment context, like Eichmann, like Grace, like Illinois, Williams versus Illinois, it illustrates that the government can't justify the constitutionality of a law based on facts that are irrelevant. I mean, it's an as-applied test. And so the question is,
relevant. You're conceding it's relevant. You're just saying that even if it is relevant, we can't consider it if it's not charged.
well, I'm not conceding, I'm conceding it's relevant if you attempted to revoke someone. I'm not at all conceding it's relevant to 922G1. I mean, it's decidedly not. And under Your Honor's reasoning, Mr. Richardson
I
would have
guess it's
been.
relevant to whether he could be constitutionally disarmed, but you're just saying we can't consider it based on the way this case was litigated.
we can't consider it because, I mean, to be clear, 922G1 would always be unconstitutional as applied to Mr. Richardson. What might not be unconstitutional is a revocation of supervised release, because that has to do with how supervised release is applied.
So sorry, you're losing me.
Makes sense.
You're losing me here. Take the facts of this case, and the government moves to revoke supervised release based on Richardson having the firearm, and that succeeds, and he goes back to prison.
Yes.
Then what?
Then if we had brought a Second Amendment challenge, and like all the facts were established, and I just note the government did not make these arguments in its briefing below about its as-applied challenge. So we've obviously argued waiver, and I just, I want to engage with Your Honor's questions, but I just want to put that on the record. I think probably that would be fine if the government had invoked authority like from Congress, from statutes that allow supervised release revocation and make that relevant to the application. Then I think that would be fine.
What if they had moved to revoke his supervised release, but it just isn't in the briefing or wasn't considered? Because there is a chance that have they done that? I mean, I would be surprised if they hadn't moved to revoke his supervised release.
I don't think they have. I mean, the PSR says his probation was completed successfully, but it's not relevant to 922G1.
Wait, I'm sorry. It was completed successfully despite the fact that he got this conviction while he was on.
That's what the PSR says. Which is why it's not clear to me he was on supervision. I mean, that's a bizarre statement in the PSR. And I just don't know what to make of this record, given that it says his probation was completed successfully.
Well, probation is different from supervised release. Could it be, he had 2 prior CPWLs because could he have completed one of them and not supervised release on the other?
I don't think so. I've seen no indication of that.
I don't think they would call supervised release probation in a PSR. It would be a totally different thing, right?
Well, I believe, we've been talking about supervised release, but I think the these are both like state DC charges. I believe we're only ever talking about probation, and we've just maybe
There
been
was
a
a
little.
10-day gap, right, between the indictment and the end of his period of supervised release. Isn't that right?
According to the PSR, it ended 10 days later.
Right. So, the most likely scenario is that the probation office didn't know, right, that he'd been indicted again.
I have no.
No, we don't know, but that's.
We don't know, which is why I think resting a fact.
But if we do find.
This court's decision.
We do find that there's a prohibition on arms in the PSR, that's more relevant.
So I just think.
I take your argument. I know what you're.
Yeah, given the confusion here on this record, it would be inappropriate to rest on the supervision. But I just want to get back to this idea because clearly I've confused everybody and I really don't mean to be confusing. 922G1 disarms someone based on their prior conviction. It has nothing to do with supervised release. So while someone might be able to be like constitutionally incarcerated.
But 922G disarms somebody based on their prior conviction, merely based on the fact that the length of incarceration is a year or more.
Yeah.
It doesn't on its face allow us to get into what was the conviction. But you're saying we can do that. And if we can do that, why can't we look at whether he's on supervised release? Because we're looking beyond just what 922G says.
So I think the way to think about it is that Mr. Richardson is disarmed based on this CPWL conviction and that.
But 922G doesn't distinguish between CPWL or mortgage fraud or anything. It just says prior felony. And you're asking us to look beyond that. And why is it that we can look beyond that to see what the felony was, but we can't look beyond it to see the circumstances of this defendant? Like what's the, I guess
because of the longstanding.
You want to.
I guess because of the longstanding idea that the government can't justify the constitutionality of its regulation by arguing that it could have properly written a statute that would have been constitutional had it written.
I don't understand that. I don't understand what you just said.
Okay,
That sounds like an argument lawyers sometimes make in a facial context to, claim the right to a facially constitutional rule. Doesn't sound like how as applied challenges normally work. As applied challenge, I mean, you got, lots of cases, you have a statute that prohibits a bunch of different things and someone wants to bring an as applied First Amendment challenge because the charged conduct in the case involved speech, and you look at the facts of the case.
so respectfully, I don't agree that I think there's ample precedent for the idea that particularly when you look at Rahimi, is not the way to go about doing
And
an as applied
you're-
challenge here.
Conceptually, you're resting on cases like Eichmann and.
Yes.
Okay. Anything else? Okay, thanks. We'll give you some rebuttal.
Thank you.
Mr. Glasser. Probably.
Thank you.
Up a bit.
May it please the court, William Glasser for the United States. The Second Amendment does not protect Mr. Richardson's possession of a firearm. In this case, his as applied challenge cannot fail and cannot prevail. And his facial challenge that I don't think has been really at issue here certainly fails under the standard that Supreme Court articulated in Rahimi and this court's decision in Medina. I'd like to start with Medina because I think that's the most straightforward way for this court to resolve the case. This court applies a fairly strict standard for determining that the Supreme Court has overruled prior precedent. This court said that the Supreme Court decision must clearly dictate a departure from circuit precedent or effectively overrule or eviscerate circuit precedent. Now, it's true, as Judge Katsas, you pointed out, that there are some differences in the analysis under Medina in a sort of a post-Bruin world, but Bruin reaffirmed what Medina did, which is to apply a historically based analysis. Medina said, quote, to resolve this question, that is the constitutionality of G1, we must look to tradition and history. And that's exactly what Bruin said courts must do. So although there might be, areas on the margins where this court would not write Medina in exactly the same way today, Medina is still binding on this court because the Supreme Court hasn't eviscerated that decision.
I agree with you on the virtuous citizen part of Medina, but I read all of the history and tradition in Medina flowing from or analyzed under the premise that it was Medina's burden of proof to establish relevant tradition. That would seem to infect or at least make incomplete the court's analysis of the history and tradition.
Your Honor, I don't think Medina was clear on which party bore the burden. So Medina started out by talking about the historical tradition of executing felons or at least authorizing the death penalty for felons and only mentioned something that could be construed as burden language in the second paragraph when considering or the sort of second point when considering whether only dangerous persons could be disarmed. And there, Medina said none of the sources cited by Medina compels this conclusion. I mean, I think that this court could easily, while leaving the burden on the government, say that the party without the burden hasn't shown anything to sort of rebut the government's showing. So I'm not entirely clear that Medina was speaking in burden language, but I think if you reread Medina with placing the burden on the government, Medina could still come to the same conclusion. So I don't think you should sort of overread that one sentence in Medina as improperly placing the burden on the civil plaintiff there.
Or maybe that was harmless error.
Sure. I don't think it affects the bottom line of the decision, Your Honor. And as we've demonstrated in our brief, there are sort of two historical traditions that we think support Section 922 G1, even in a post-Bruin world. Medina primarily relied on the first of those traditions, not the disarming of the dangerous, but rather the fact that
Treatment of felons.
that's correct, Your Honor.
Right.
we think that the dangerousness rationale is just further support that would support this court's decision in Medina. The Ninth Circuit, for example, in the en banc Duarte case, relied on both of those traditions to uphold Section 922 G1. And I would point out that 6 other circuits have actually just relied on the Supreme Court's statements in cases like Heller that Section 922 G1 and similar statutes are presumptively lawful to conclude that Bruin didn't overrule prior circuit precedent. Those courts didn't have anything nearly as strong as Medina, which applied that historical tradition test. But I think that even those courts' analysis is persuasive and relevant because those courts concluded that the Supreme Court statements about felon dispossession statutes were enough to indicate that Bruin was not clearly overruling circuit precedent.
You may or may not be right about Medina. Strikes me as a little messy, but the government, is there some reason why we shouldn't just have a narrow, bright line rule that the statute is constitutional as applied to individuals on supervised release?
Your Honor, we wouldn't have any quarrel.
Seemed to me the easiest. Unanimous circuits.
Sure.
Got a pretty aggressive opinion by Judge Hardiman, who has been very protective of the Second Amendment, and he thought this was an easy case in your favor.
So, Your Honor, we certainly wouldn't have any quarrel with a narrow ruling like that. I would note, though, that as my colleague here pointed out, the Third Circuit has sua sponte granted rehearing en banc in two cases that sort of follow on from Judge Hartman's decision and more. So those cases are Bost, which is a criminal case, and
How do you spell it?
Bost. I apologize, I don't have the case number in front of me, but Bost, and then Williams versus the Attorney General, which is a civil case. In both of those cases, the Third Circuit granted rehearing sua sponte and asked for briefing on this question of whether you can consider conduct that that's not charged or occurs after the underlying conviction. So although we would be perfectly happy with that rule in this case, I worry that the question would be up in front of this court again in the next 922 G1 case where someone was not on supervision. And
That's not our problem.
fair enough, Judge Ginsburg. But also that is at least a matter of dispute within the Third Circuit. So if you're going to,
it just seems like that is a not insignificant ruling for the government, and we have another Second Amendment case pending in the Supreme Court, which between now and June we might get more guidance on dangerousness writ large.
Yeah, Your Honor.
It just seems like prudentially that might be the narrow, sensible way for us to deal with this.
We would be perfectly happy with a narrow win as opposed to a broad one. I'm not sure that the Supreme Court in the Hamani case is going to resolve a lot of questions that relate to 922 G1, but as you mentioned, perhaps their discussion of dangerousness in the 922 G3 context would shed some light on the other rationale, not the one that Medina primarily relied upon. I'm happy to answer any further questions if the court has them. If I can just briefly touch on some of the questions about the underlying facts of this case. The question about whether or not Mr. Richardson was on probation or supervision at the time of his offense, I think it's undisputed. In the undisputed facts in the PSR indicate that he was on supervision. His supervision term expired 10 days later. I think it was the PSR uses the term supervision and supervisory probation. I think because this was in Superior Court, it was not federal supervised release. It was Superior Court supervision. But it's clear that he was on some form of supervision. It's strange that it was that the PSR says that he successfully completed it, but it's not disputed that he was on supervision. And regarding the question of whether he was prohibited from possessing firearms while on probation, I pulled the Superior Court record, which I think this court could judicially notice if it chose to, and found that although he was not specifically prohibited from possessing a firearm, he was ordered to, quote, obey all laws, ordinances, and regulations. And so his possession of a firearm would violate federal law under 922 G1. It would violate DC code because he's once again for a third time carrying a pistol without a license. So should this court choose to rely on that that sort of narrower ground to uphold the statute's application, I think there would be ample evidence in the record and judicially noticeable evidence to do so.
And what's your response to your friend on the other side's assertion that we can't consider things like supervised release, even if that's true?
Sure. Your Honor, the government's view is that the way to think about an as-applied challenge is that when you have a law that is facially valid and or presumptively lawful, as the Supreme Court has said, then it's really the defendant has to, and this is consistent with Medina too, the defendant has to do something to take himself out of the sort of mine run of applications where the law is constitutional and show that he's somehow different from those other people. He needs to show that he's different from Medina, who engaged in mortgage fraud. And this court concluded that that 25-year-old mortgage fraud conviction was enough to disarm him. And in order to do that, it seems like it's perfectly fair to consider not just the bare allegations in the indictment, which the allegation was simply that he was convicted of a crime punishable by for a term exceeding 1 year, and consider the defense wants you to consider the nature of those underlying charges, which is, I think, as you pointed out, an inconsistency in their view. But the government's view is that once you are trying to demonstrate that you don't fall within that sort of within the group of people to which a statute can be constitutionally applied, you have to show that based on your specific circumstances, and the government then can come back with additional specific circumstances to say, no, this is a perfectly constitutional application to this person.
Do you have any case law or authorities that support this view, which makes a lot of sense to me, but.
So, Your Honor, we do have the decisions from the Third and the Fifth Circuit. The Sixth Circuit says that it's really totally an anything goes analysis. In the Williams case, we've cited these in our brief. The Williams case from Sixth Circuit, Diaz from the Fifth Circuit, and the Moore case, which again maybe has had some doubt cast on it in the Third Circuit. So beyond that, I do think that if you read the Supreme Court decisions that the defense relies on, such as Patel, they're misunderstanding what those decisions said. So Patel dealt with a law that allowed the city to engage in warrantless searches, and the government of the city responded in defense of that law that, well, you can think of at least some valid applications of this warrantless search statute because maybe there was consent. And the Supreme Court said, well, if there's consent, you don't even apply the warrantless search statute. So there's just no application. The law has no work to do. In this case, it's very different because here, Section 922G1 clearly has work to do. It applies to someone who has been convicted of a crime punishable by a term exceeding 1 year. The question is just whether there are some additional facts beyond those elements that might show that it was constitutional or unconstitutional as applied to someone.
So Patel suggests that if a defendant came in and said, this is not constitutional as applied to me, the government can say, but you consented. And so therefore it is constitutional as applied to you.
No, Your Honor, but that's not what Patel said. Patel said that if in the context of a warrantless search statute, that the government can't defeat a facial challenge by hypothesizing non-applications of the statute. So if I were here saying, well, Section 922 G1 is constitutional.
Connect it to the question before us, which is, can we consider things beyond what?
Yeah. Patel didn't resolve that one way or another, Your Honor.
Okay.
Patel is a facial challenge.
That's correct.
It's facial challenge law. It's about how to apply Salerno and what the relevant denominator is for all possible applications.
That's correct.
Inquiry, I thought.
That's absolutely correct. And the reason that Patel doesn't support Mr. Richardson's argument here is that Patel, despite contrary to what Mr. Richardson argues, Patel doesn't say that that a statute like 922 G1 has no application in this context. It clearly has the application in this context. What Patel simply said is you can't hypothesize non-applications of a statute in order to defeat a facial challenge. Here, in order to defeat the facial challenge Mr. Richardson raises, we're not raising non-applications of a statute. For example, an application of this statute as applied to someone with a murder conviction, that's an application of the statute, and we're saying that's clearly constitutional. He can't win on a facial challenge. So that was my only point with respect to Patel.
Just for a second, back to your exchange with Judge Pan about how as applied challenges work. And you said that the defendant statute that is facially constitutional, no problem applying this statute to murder predicates. The defendant or the challenger in an as-applied challenge has to do something to take himself out of the heartland of the statute. And that seems right to me in general. But is there any tension with the instruction in Bruin that the government bears the burden of proving the relevant tradition with sufficient specificity? So like they do that writ large for felons, and that establishes facial constitutionality. And then you have an edge case with the conviction for opening the ketchup bottle or whatever, some weird felony.
Right.
You said it's the challenger has to do something to take him out of the heartland.
Sure.
Why isn't it the government's burden to show that the general tradition extends to the kind of conduct in the case?
Well, Your Honor, I'm sort of going beyond what the Supreme Court has clearly addressed, but here's how I would think about it. And these are admittedly complicated issues. The way I would think about it is the government's top line view that's consistent with Medina is that we have shown that Section 922 G1 is constitutional in all its applications. To the extent there are questionable problematic cases, Congress dealt with that in 925C, which the department has recently revived. And so you don't need, there's sort of
925C?
I'm sorry, Your Honor, the Section 925C, we cite this in our brief, is a statute that Congress passed that says that someone can regain their right to possess firearms if they can show they're not a danger to the community. So that
Petitioning the Attorney General, wasn't it?
that's correct. Petitioning the Attorney General. So that's our sort of top line view.
Okay.
But so let's assume we're wrong.
Suppose I think you've proven constitutionality for the heartland application, but I'm worried about these edge cases.
Exactly. In that situation, Your Honor, I think the best way to think about it would be to say that the defendant needs to come forward with something to show that he falls outside the heartland. It would be very odd if the government had the burden of digging up every possible fact about, the age of the defendant's criminal history or his rehabilitation, that sort of thing. Again, I could be wrong on that. And if the government does bear the burden even there, I think we could satisfy it in Mr. Richardson's case. But I think the defendant would need to come forward, say, at least make an allegation and a motion to dismiss an indictment saying, this can't be constitutionally applied to me because of X. And then I think the government would have the burden of showing
It's a burden of production or articulation, and then you show that the tradition applies with sufficient clarity.
That's correct, Your Honor. So I think probably the best way to understand the Supreme Court's decision in Bruin is that the government bears the burden of persuasion on the constitutional question at the first level, general, in sort of the general applications, and then when facing an as-applied challenge, can respond to the defendant's challenge. And our view is that when we're responding to that challenge, we can point to things outside of the bare elements of the offense, because that's exactly what the defense is doing in that situation.
That makes sense. Okay. Judge Pan, anything else? Judge Ginsburg?
Thank you. We would ask the court to affirm.
Thank you. Ms. Millian, we'll give you 3 minutes.
Thank you, Your Honors. Really quick to start, I actually have the case number for the Third Circuit case where they granted en banc. So in Boost, it is 24-17-19. And that cites the civil case where they granted en banc review as well in that en banc order, and that'll have the case number for that case for you.
I'm sorry, one is 24-17-19.
And unfortunately, I don't have the case number for the other one, but if you
What's the pointer? We'll find it in Boost.
Yes, exactly.
Got it.
So Your Honor asked some questions about whether the burden makes a difference in the Medina decision. And I just want to quickly dwell on that for a minute, because I think it makes a huge difference in why the court came out the way it did. It specifically noted that there were few primary sources directly on point. It noted the absence of founding era regulations disarming individuals for past convictions. And it used language like on balance to describe the way it was coming out in that case, indicating that it found the issue to be in relative equipoise. And so the fact that it seemed to understand the burden to rest with the plaintiff is what drove its decision. That was the main point I wanted to make, but I welcome any additional questions you all have.
Japan, anything?
I know it's not entirely clear in Medina, but I just remember seeing them noting that it was the government's burden, at least to the extent of proving that the defendant was dangerous. I just don't think it was very clear that they were assigning the burden to the defendant.
Let me, if you don't mind, let me grab a copy of it.
Okay.
So I'm not sure what you're referring to, Your Honor, but I mean, the points that I mentioned before, I think demonstrate the importance of the burden. It specifically notes that none of the sources cited by Medina compels the conclusion that only dangerous people can be disarmed, which of course was the context of his as-applied challenge. He'd argued that only dangerous felons could be disarmed. And it says things like, to the extent it may be possible for a felon to show that his crime was so minor or regulatory that he did not forfeit his right to arms by committing it, Medina has not done so. Again, that's evidence that the court is placing the burden on Medina to prove that this a particular historical tradition permits him to carry his firearm rather than the reverse.
Okay. Thank you.
Judge Ginsburg? Okay, thank you, counsel. Thanks to both counsel for really exceptionally good briefing and advocacy. We appreciate it. The case is submitted.
Case number 24-3048, United States of America versus Artie Byrd, appellant. Ms. Bhatti for the appellant, Mr. Hobel for the appellee.
Ms. Bhatti, good morning.
Good morning. Good morning, may it please the court. Isra Bhatti from the Federal Public Defender's Office on behalf of Mr. Artie Byrd. I'd like to reserve 2 minutes for rebuttal. Mr. Byrd appeals his conviction and the reasonableness of his above guideline sentence on various grounds. I'd like to begin with the procedural unreasonableness of his sentence, which more than doubled the median for similarly situated defendants. The court justified its upwards variance on 2 grounds. First, by relying on conduct that Mr. Byrd was acquitted of in a completely unrelated case from Superior Court over which the sentencing judge did not preside. And second, by concluding that Mr. Byrd's criminal history understated his quote dangerousness and neither ground was justified. With respect to acquitted conduct.
Sorry,
Court's
how do you
use-
get the more than doubled?
I'm sorry.
How do you get, you said more than doubled?
The median for similarly situated defendants was 35 months. And the court sentenced
Of
Mr.
the
Byrd
range
to
of-
72 months.
Guideline range is 41 to 51.
That's correct.
Right?
That's correct. And the median was for individuals in the same criminal history with the same base offense level.
Okay.
The court's use of
I don't
acquitted
understand that.
conduct.
So people are downwardly.
The median sentence was, yes. The mean was 42 months for similarly
I'm
situated
just
defendants.
confused that the mean could be below the guideline range.
The median?
The median could be.
Right. Presumably there are outlying individuals that skew the average upwards. And so the median was 35 months.
Okay, that confuses me.
I'm happy to explain it further if the court would want. So the court's use of acquitted conduct was problematic in three ways. First, because acquitted conduct sentencing is unconstitutional, and particularly in a situation like this, where the acquitted conduct was completely unrelated to the offense of conviction, and the district court did not preside over that unrelated case.
So my understanding is that acquitted conduct is permissibly considered. There's precedent to that effect. I understand if you're trying to preserve a challenge to that, but is there any authority about whether that acquitted conduct has to be related to the case before the court?
Sure, Your Honor. We would start with Watts itself. Watts is the kind of grandfather of all of these cases, and Watts itself was a fairly narrow decision. Watts considered a double jeopardy challenge to the kind of quintessential acquitted conduct case. In that case, the individual was convicted of possession with intent to distribute, acquitted of having a firearm in association with that offense. And the judge found by preponderance that the individual did have a firearm in association with the possession offense, and therefore enhanced his guideline
But does
range.
that mean that you can't consider acquitted conduct that was not
So
before the court in the case so far?
So the way that Watts justified its decision in the double jeopardy context was to say that that a sentence based on the acquitted conduct does not punish a defendant for crimes of which he was not convicted, but rather increases his sentence based on the manner in which he was convicted of the crime of conviction. So the court was distinguishing the manner in which a situation in which the acquitted conduct had something to do with the manner in which the convicted conduct took place, rather than
guess my
simply the
question is,
individual.
If that's one permissible way to do it, does that mean you can't do it in these other ways? Because since Watts, I don't think it has to necessarily be the way you're positing.
So Watts involved that situation, Settles involved the same exact fact pattern. And every case that followed in this circuit, every case that the government cites in their brief, and all of that Watts Settles lineage involves cases in which the conduct is related somehow, and the district court has presided over that unrelated case.
But there is no case that's directly on point that says you can only do it the way you say, and you cannot do it the way the district court did it.
Perhaps because it's such an egregious way to do it, the way that the district court did, because the district court did not.
Is your answer that there's no direct?
I have not seen a single case involving the use of unrelated conduct where the sentencing judge did not preside over that unrelated case. I'll just note, I know that you think it's egregious, but having presided over a lot of trials, and especially in the Superior Court, this is not an uncommon thing to do over there. Well, even if the court were to think that this is in general an uncommon thing to do, the way that the judge
I'm
did
just saying,
so
you're
this
saying it's egregious, but I'm saying it happens a lot.
Your Honor may be correct.
The government, I guess it's the same U.S. Attorney's Office, they will provide evidence of acquitted conduct from an unrelated case and say that it was proved by preponderance, and you can consider it. That's a very, in my experience, not an uncommon thing to happen.
So, and that, in that situation, obviously there are all the problems that many courts and judges have opined on.
I guess part of it is it's happening a lot, but you don't know of any cases that say you can't do that. This would be the first.
So yes, I have not seen cases involving that. And in addition to that, I would say particularly in the manner that the judge did here, where he did not preside over that unrelated case and involved, right. And obviously had not seen these witnesses. The government did not call the witnesses. The court did not examine the witnesses, and there were active, their testimony was actively contested by the defense.
I understand that everything that you're saying. I'm just saying that I think it happens a lot. And I think that
Your Honor may be
district
correct.
judges typically don't, or trial judges typically don't hear testimony, et cetera, when it does happen, because it's only by preponderance of the evidence, which is a low bar. So transcripts, et cetera, are often consulted when this happens. Yeah.
Your Honor may be correct. We would still say that the procedural issues that were present in this case involving the courts using the cold transcript to credit some testimony from an individual whose reliability was contested and to, without reason, dismissing these other aspects of his testimony, which were problematic. For example, crediting the unsworn single photo array identification of Mr. Byrd, and as opposed to the in court failed identification without explaining why one was more persuasive than the other. Attributing the statement, take that loss like a champ, which
But it's, a clearly erroneous abuse of discretion type standard, right? I mean,
Right,
we can't
but-
fly spec credibility determinations.
I'm sorry.
We can't fly spec credibility determinations like that.
Well, the court is obligated to consider the conflicting evidence and to explain why the court is deciding to use one identification over another, or to attribute the statement as a basis for intent to Mr. Byrd, to Mr. Chambers when dismissing an entirely contradictory statement. And there were a number of issues with Mr. Chambers, with Chambers's testimony that we highlight. And the court at no point tried to distinguish that contradictory evidence. And I think that's a problem. And that we would refer the court to the Barker decision, where the Seventh Circuit indicated that the judge has an obligation to do a searching inquiry into the contradictory evidence and distinguish it. And the court did not do that here. So as a procedural matter, even if the court decides that constitutionally this was permissible, procedurally, this was an abuse of discretion. And then taking it a step further, we still think that the preponderance standard was not satisfied. None of the evidence here was uncorroborated and or unsworn hearsay with no other marks of reliability. In that way, it's very similar to the Rivera-Ruiz decision from the First Circuit, where the court found that findings based solely on unreliable evidence cannot establish a preponderance standard. So we would refer the court to that decision.
We're still reviewing for clear error, right?
Right. And Rivera-Ruiz said that because this unreliable evidence can't establish a preponderance, it is therefore clearly erroneous. So for that reason, because it can't establish a preponderance, it is clear error. I would just wanted to also speak briefly about the other procedural unreasonableness issues that we have raised in our brief, which namely, the court never distinguished this case from the mine run, so the universe of similarly situated defendants. We think that was also an issue. At no point did the court explain the degree of variance adequately, and so we would also ask this court to consider that as an abuse of discretion by the district court.
Is there any, on the Second Amendment question, is there any feature of this case that's different from the one we just argued? I don't know if you heard the argument.
Yes, I
is there
did.
anything-
I would just point out that Mr. Byrd's predicate offense is what the district court called a juvenile adjudication, and the court has not provided, the government has not provided any historical analog for lifetime disarmament based on a juvenile adjudication.
Okay, thank you. We'll give you a rebuttal. Mr. Cobell.
Good morning, and may it please the court. The district court, Mark Cobell for the United States. The district court did not abuse its discretion procedurally or substantively in imposing a 21-month upward variance, that's less than 2 years, for a third felon in possession offense committed while on supervised release for the second by a defendant with a history of committing violent crimes that was not fully accounted for in his guidelines criminal history score. The district court here properly considered the acquitted conduct underlying Byrd's acquittal for accessory after the fact for assault with intent to kill while armed in superior court. In terms of precedent for handling unrelated conduct, that's acquitted under Watts. We'd refer the court to Watts itself and the reasoning there. Watts relied on 18 USC section 3661. In fact, it began its analysis with that statute, which says no limitation shall be placed on information concerning the background, character, and conduct of a person convicted of an offense for the purpose of imposing an appropriate sentence. The court also relied on Williams v. New York, in which a sentencing judge had relied on 30 uncharged burglaries and out-of-court evidence of that to impose the death penalty in a New York case. And so Watts summarized 3661 and Williams as neither the broad language of 3661 nor our holding in Williams suggests any basis for the courts to invent a blanket prohibition against considering certain types of evidence at sentencing. So we think the logic of Watts fully supports what the district court did here and completely refutes this artificial distinction between related and unrelated acquitted conduct for purposes of sentencing, the 3553 factors. I would direct this court to.
Is there any limit on the position you're advocating? I mean, Watts was a couple of decades ago, and we have Apprendi jurisprudence and increasing emphasis on the need for jury findings and the need for pure proof beyond a reasonable doubt. At some point,
Right.
does it
Not with
too much like you're really sentencing based on district court fact finding by a preponderance?
I mean, notwithstanding the language of 3661, which literally says no limitation shall be placed on the information a district court may receive. There are limitations and safeguards in place that it has to be proved by a preponderance of the evidence. There are numerous procedural. It has to be explained procedurally to support a variance, and of course, although it doesn't, it's not. Necessarily, it's not relevant here because this was not a guideline sentence. In fact, the guidelines, the Sentencing Commission just changed the policy statement and the guidelines to my understanding is to make it more difficult to
Consider acquitted.
Yes, correct. So there are limits, but again, going back to the logic of Watts in the cases this court has applied, Watts and like settles. Is that there is not, there is a broad range of information a sentencing court can consider in imposing a just sentence for the individual. And in this case, this was a trial in Superior Court that took place literally right before the retrial in federal court on the felon in possession case. And it was information that directly refuted some of the arguments that Mr. Byrd made at sentencing, that he only armed himself in self-defense, that he was that he had armed himself because of traumatic experience he'd had after he'd been released from prison on his previous felon in possession conviction. So it was directly relevant to the sentencing decision. It was important to share this with the court, and the court made the proper findings and found by a preponderance of the evidence, and its findings were not clearly erroneous. And it fully explained why it credited the identification by the victim, Jermaine Chambers, in the Awick case.
Did the same district judge preside over the first trial?
No. So that was, I believe it was Judge Raffin in Superior Court presided over the Awick while armed.
No. I mean, there was a hung jury in this case, correct?
Correct, yes. Yes.
Did the same federal district judge preside over the first case where the jury was hung?
Yes, it was Judge McFadden in both cases.
So this is bringing to his attention something that happened in between the first and second trials that came before him?
That's right. I believe
that makes it, I think, even more relevant, doesn't it, to the sentencing?
Yes. I mean, I think it was directly relevant. It was certainly,
because he was on release in Judge McFadden's case then when this happened?
Oh, no, I'm sorry. No. So because of the pandemic, a lot of these trials were delayed. So the Awick, the conduct underlying the Awick accessory acquittal, that took place, I believe, in 2019.
Sorry, Awick?
I'm sorry. Assault with intent to kill while armed. So I'm lapsing into my DC code Superior Court speak. I'm sorry. That occurred in 2019. That occurred before Mr. Byrd's second felon in possession conviction, but the trial in that case in Superior Court occurred in the same month, immediately before the retrial in this case, if that chronology makes
Okay,
sense.
so the conduct occurred before the first trial, but the retrial occurred, I'm sorry.
Yeah.
I'm just trying to understand from Judge McFadden's point of view, how these events related to the fact that there was a trial and then a period and then a second trial. And so this defendant was on release in Judge McFadden's case for some period of time, but you're saying the AWIC occurred before even the first trial in this case.
Correct.
So what is it that happened right before the second trial?
It was the trial for the conduct in Superior Court.
Oh, so
the acquittal. I'm sorry.
Okay,
Yes,
I
the
see,
acquittal.
I see.
Yeah.
I see.
I'm sorry for any confusion
No,
there.
that's
but-
okay. That's okay. I'm just thinking from the point of view of a sentencing judge, while you were on release in my case, you went on trial in Superior Court and you were acquitted. But it just seems relevant. It's not a completely unrelated thing. Just temporally, you are on release in my case as the federal district court judge when you got acquitted. And so for the government to bring to my attention that what happened in that trial does not necessarily exonerate the defendant who's being sentenced before me, it just seems extremely relevant based on that timing.
I think that's right. It goes really to the history and characteristics of the defendant
But counsel's point stands correct that Judge McFadden did not try the case on which he's drawing.
That's correct.
Okay.
But sentencing courts frequently are called upon to rely on hearsay. And we cited to this court's precedent in Miller, which is one of many precedents that say that hearsay is admissible in a sentencing proceeding. And in this case, there was reliable hearsay. It doesn't get more reliable than sworn testimony that's subject to cross-examination in a recent prior trial. So Judge McFadden carefully reviewed the trial transcripts, the grand jury transcripts, the evidence in that case, and made findings that were not clearly erroneous. I would point out, just as a factual matter, there's been in Mr. Byrd's reply brief, there was a suggestion that our proffer that Byrd did not work at United Masonry with the victim and was not his coworker, that was not supported. I would direct the court to page 19 of the PSR in this case, in which Byrd admitted that he worked at United Masonry from January to April 2019, which is entirely consistent with the victim's testimony in the AWIC well-armed accessory case about who AR was, the person who was involved in the robbery and the shooting. And just briefly, very briefly on the Second Amendment point, just to loop it back into the case before us. This defendant, Mr. Byrd, was on supervised release, just like Mr. Richardson. So to the extent that the court were to embrace that sort of narrower logic that Your Honor, Judge Katsas alluded to in that case, it would cover Mr. Byrd's case as well. So unless the court has any further questions, we would ask the court to affirm.
Thank you.
Thank you.
Ms. Beatty, we'll give you 2 minutes.
Thank you. I just wanted to point out a couple of things. One, in the denial of cert in McClinton, which was the case involving acquitted conduct, where 4 Supreme Court justices explicitly stated their overriding concerns with acquitted conduct sentencing, but decided not to grant cert because the Sentencing Commission was actively considering the issue. There's an important sentence in Justice Sotomayor's statement, which is the fact that even though a jury's specific reasons for an acquittal will typically be unknown, the jury has formally and finally determined that the defendant will not be held criminally culpable for the conduct at issue. And here we have that exact situation where the jury decided that Mr. Byrd would not be held criminally culpable. The government comes to this court and decides to hold him criminally culpable for that conduct expressly.
I guess he's held culpable for what he's being sentenced for, but within the range, it's a factor that can be considered. Is that analytically what's happening?
I'm sorry, can you repeat that?
he's criminally culpable
Mhm.
for the crime of conviction and he's being sentenced. And I guess the case law says you can look at anything in deciding what's the correct and reasonable sentence within the range. And this is just one factor. So it's not the same as sentencing him for the acquitted conduct. It's determining the sentence for the crime of conviction and using this as a factor.
So here, again, we go back to Watts and how this all started, right? But the statement by Justice Sotomayor expressed, I mean, this is the crux of the issue with acquitted conduct
So
sentencing.
I'm
Is here-
interested
Mhm.
in, I guess, your views of somebody like Al Capone. You know, he was convicted of tax evasion despite committing lots and lots of murders and other things because he was a mafia
Mhm.
boss. And then he gets the highest sentence ever for tax evasion. Do you think that was improper?
This is a completely different scenario. I mean,
No,
we have,
I'm just in general, I think that they consider the acquitted conduct.
I don't know if they considered his acquitted conduct that was in any way related to his other conduct. And so,
Assume it wasn't.
I mean.
I don't think it was.
Then
Just-
it's a problem. I mean, acquitted conduct sentencing in general is a problem for all the reasons that Justice Sotomayor identified in her statement in McClinton. It's particularly a problem here where we have Mr. Byrd acquitted in Superior Court. The jury has closed the door on punishment. The government comes here and the district court expressly enhances his sentence based on the uncounted, the district court's words, uncounted
So there's
acquitted
no
conduct for the
situation-
AWIC situation.
I'm just, I know this is just kind of a theoretical question. So you're thinking that in no situation is it ever appropriate, like even for Al Capone, who they were not able to convict on murders that, let's assume he did commit, and they can only get him on tax evasion. You
I
think
would,
they
I would
can't
say.
con- They can't consider the murder.
I would say yes to that situation for, again, all the reasons that Justice Sotomayor and Justice Kavanaugh and Justice Barrett and Justice Gorsuch have all expressed. And I would say particularly in this type of a situation, it's especially egregious. And I wanted to just point out a couple more things. The government's logic that there's no restriction based on the language of 3661 on what a court can consider in sentencing would really know no bounds. And that would, that's not the law. We know that the Sixth Amendment applies. We know that the Fifth Amendment applies. We know that hearsay must be reliable. We know that the defendant cannot be sentenced based on inaccurate information or speculation. And here that's what happened. There's nothing that connected AR to Mr. Byrd outside of chambers, unsworn, single array photo identification in the hospital. The testimony from Eric Rubio never connected AR to Mr. Byrd. This was a classic case of misidentification. And I mean, for all the reasons that we've already stated in our brief, there's a huge problem with using this because what it boiled down to was the district court speculating as to the reasons why that failed identification happened. Hairstyle change, passage of time, all those factors were expressly put in front of the jury and the jury rejected those reasons. So for that reason, we would say that this is an abuse of discretion by the district court. We ask this court to reverse.
Thank
you.
you, counsel. The case is submitted.
Case number 23-1227 et al. Cage Ranch Solar LLC and Cage Ranch Solar 2 LLC petitioners versus Federal Energy Regulatory Commission. Mr. Ticey for the petitioners, Ms. Gal for the respondents, Mr. Binet for the intervener.
Mr. Tyson, good morning.
May it please the court, I'd like to reserve 3 minutes for rebuttal, please. A fundamental methodological flaw in Southwest's testing process inflated the costs Cage Ranch owed for interconnecting to the Southwest grid by hundreds of millions of dollars. Southwest assigns to new generators the costs for grid upgrades that would not be necessary but for those generators' connections.
Can I ask you a question about standing counsel?
Sure.
So it seems to me that although your client was assessed $311 million in costs, it voluntarily withdrew from the interconnection process. So it was not financially injured by that assessment. And I guess my question is how that voluntary withdrawal from the interconnection process affects standing. Because given that there's no economic harm because of the withdrawal, the only harm, it seems to me, is that your client lost its place in the queue. And if that's the harm, then we have both a causation and a redressability problem, because the causation of losing your place in the queue was not the mistakes in the studies. It was the withdrawal of your client by failing to pay the deposit it needed to pay. And then there's also a redressability problem because fixing the problems in the interconnection study is not redressed by putting you back in the queue. The queue question relies on a different four-part test. So why does your client have standing to challenge the problems with the study?
Sure, Your Honor. There's a lot in there, so let me take it piece by piece. Now, if I forget anything, I'm sure you'll remind me. But first of all, we have standing. We've been injured by this process. We were kicked out of the queue. It was not a voluntary withdrawal, and it's a bit of terminology, but we did not pay the fee, the
But
deposit.
wasn't that a voluntary choice?
And it was a voluntary choice not to pay it, but as part of this dispute resolution process, we filed a complaint. We sought a waiver of that process. So it was not a voluntary withdrawal in the sense that we did not want to be in the queue. We wanted to remain in the queue. We just wanted to pay the correct amount. So I think we were clearly injured by that process. These are very valuable.
Sorry, you're
queue-
injured by, I'm just trying to be more precise.
By being removed from the queue when we did not want to be removed from the queue.
But if your argument hinges on being removed from the queue, it just seems to me that it's because you didn't pay the deposit. If you wanted to remain in the queue, you could have paid the deposit and remained in the queue. Isn't this a self-inflicted injury as opposed to one that was inflicted? I guess there's a finding by FERC in its decision that the cause of the removal from the queue was not the process. It was your voluntary decision not to pay the deposit to stay in the queue.
Your Honor, I mean, just to be clear, we challenged the process. We said, you're asking us to post $60 million in at-risk security that we will lose if we later withdraw from this process based on a study process that is inherently flawed. At the same time, we asked the commission, well, first we asked the commission to essentially excuse the deposit requirement. If this court were to agree with us on those points, that's clearly redressable. The court would say,
okay, well, you can't rely on us ruling in your favor on the waiver issue in order to establish standing on the study issue, because you have to prove standing for each claim independently, right? So just looking at your claim challenging the study, it seems to me that your voluntary withdrawal really changes the standing analysis. And if you had a problem with the rules, the way this works, it seems like you should have tried to amend the tariff or whatever the procedures are, but you took a gamble and said, we won't keep our place in the queue the way the rules require us to do it. And instead we'll challenge and ask for a waiver. That there's a risk in that because you might not get the waiver.
well,
It seems to me that's a business decision.
there was a risk on both ends, Your Honor. By not paying the deposit, we also, if we lose this case, we are now out of the queue. But there's lots of precedent in this court as well as with FERC. Let me start with the FERC precedent. FERC can restore queue positions. That's very clear.
There's no question that they can. It's just you're not entitled to it. And so when you made the decision not to stay in the queue by paying your deposit, you were taking a risk.
Well, I don't know why you say we're not entitled to it. On JA 351, note 45.
You
we
have to
cite-
meet a 4-part test in order to get back into the queue once you
Correct.
didn't pay your waiver. That's all I'm saying.
Correct. And the only,
you were taking a gamble that you could meet the 4-part test.
correct. We believe we do meet the 4-part test.
No, I
But-
understand.
But I also want to say that even putting aside waiver, Your Honor, FERC has equitable discretion to restore us to our queue
I
position.
totally understand that. I totally understand that. But I'm just saying in terms of standing, you can't rely on telling us you're going to win on your waiver argument that that you can get that reversed in order to establish standing on your study challenge question. You have to establish standing independently.
Your Honor, even if we had not challenged the waiver finding itself, if we only challenged the methodological problem, if we were to prevail on that and the court were to vacate FERC's order and remand,
But
FERC
I'm
would
saying you
still
don't
have
have
discretion
standing to
regardless of
challenge
the
it.
waiver.
I'm sorry? If you prevailed on your study challenge, you're out of the process right now.
Correct.
So how does this redress your injury? You're trying to get back into the queue.
Because because we were injured by the removal from the queue.
I'm just saying that that injury isn't related to the study problems that you've identified. You want
I
to
think
say there were
it's-
all these mistakes in the study.
I think they're
And even
bound.
if you're right, that doesn't get you back in the queue.
I think they're bound up together, Your Honor. And in fact, that's the way FERC briefed it. That's the way Southwest briefed it. They essentially said, look at JA 444. This is what FERC said below. Because Cage Ranch has failed to show the phase 2 study defective, because of that, now I'm quoting, we thus continue to find that Cage Ranch's argument that a concrete problem exists based on alleged defectiveness is unpersuasive.
It
So
was
it was
briefed,
bound
though.
up
All
together.
4 parts of that test were briefed. And so we can rely on any parts of it. Like we're
FERC
not.
only relied on one, and I think under
But I don't
APA
think we're-
principles, this court is
I'm
bound.
just talking about standing here, and we have an independent duty to
I
look at standing, and we don't have to rely on what FERC said. I'm just trying to understand what your injury is, which I think is being kicked out of the queue, and then if we find that you're correct about the study problems, how does that redress you being kicked out of the queue?
Well, because in that situation, you would vacate the order below that FERC said that the study process was fine, remand it back to FERC, and then FERC would decide on the proper remedy. And I would say that if you look at page 351, note 45, we cite about half a dozen cases where FERC in similar circumstances restores parties to the queue after a study process has been proven to conflict with the Federal Power Act or with cost causation principles. I'd also point out that the
They
tariff.
still have discretion, though?
Yes, Your Honor. And in fact, even if we had not challenged the waiver of our queue position, they still would have discretion to do so. And that the reason is because FERC has broad equitable discretion, number one, when there's a Federal Power Act violation, but number two, the tariff itself, section 3.7 explicitly contemplates that a tariff customer who disputes withdrawal and is removed can be resolved. And I'm quoting again, tariff 3.7. It says, once a customer is removed from the applicable queue, they are removed from the applicable queue position until such time that the outcome of dispute resolution would restore its position. So again, we have now engaged in that dispute resolution process. We've challenged the finding at FERC. Under the tariff itself, we are entitled to be restored to our queue position if we were to prove our Federal Power Act violation. So I'm happy to answer any other questions on that, but if not, I'd like to turn to the merits. And I think that the main issue, and I think the simplest and most straightforward way to resolve this case is for the court to conclude that the Southwest simply did not test for but-for causation. They looked at the grid at a particular snapshot in time with our proposed connection as part of that grid, but it was not a but-for causation test because they did not isolate the variable of our incremental impact. Instead, they added to the testing model 2 variables simultaneously. Number 1, Cage Ranch's group addition, and number 2, various
I
contingencies.
didn't hear you. What's number 1?
Number 1 was the addition of our group, our cluster.
Right.
And number 2 was various contingencies. And those are things like the catastrophic loss of the transmission line in order to evaluate the grid under stress. But that methodology simply cannot show under cost causation principles that Cage Ranch caused the need for the upgrades. Because for all Southwest knows, the same stress testing could have caused the grid model to fail even if Cage Ranch never connected. And in fact, I think if you look at page JA 321, this is Southwest's answer, they expressly admit, they say, we've never claimed that there were no non-convergences arising from contingencies in the pre-transfer case. They've come out and said it. So I don't think there's any dispute that they don't even take the position that there were potentially non-convergences. So FERC before you now says it was just irrelevant to test that, but we believe that under TANASCA, the best reading of that case is that the crucial but-for question is whether the upgrades were already necessary before we connected.
Okay, so I'm not an expert in any of these issues, and it just seems to me that there was a finding that or tell me if this is true or not, that Southwest just used the process and the analysis that they've always used, which is consistent with their tariff. And it seems to me that if you wanted to challenge the process that it always uses, you're supposed to try to get them to amend their tariff as opposed to coming in and just criticizing this process sort of in a single application.
Well, Your Honor, we're not challenging the tariff. We don't think that the tariff requires them to test in this, odd way. Again, this court requires under the cost causation principle that the upgrade costs that we're assigned are those that are necessary, that would not be necessary but for our interconnection. The tariff doesn't say anything about that, doesn't dispute that.
Right.
I do agree that this would upset some of the internal manuals, well, not even upset. I'm just saying the internal manuals don't require contingency testing in the in the pre-transfer case. But they don't bar it either. There's a lot of discretion in the way some of these manuals are actually
Are
carried
you
out.
saying that in all of their future interconnection studies, they need to do pre-transfer testing?
Your Honor, I mean, certainly if the argument is preserved as in a case like this.
Uncomfortable, like telling FERC how to do pre-transfer, how to do interconnection studies and stuff.
Well, Southwest, I mean, it's not unusual. I think there's evidence in the records undisputed that Mid-Continent or MISO does this exact testing. And again, I just want to focus on the exact reason why it's so.
But I think
important.
you're asking us to rule that they have to do this in every interconnection study, or
Well,
else it will not comport with the cost.
Yeah, I'm asking you
Principle.
to tell them that in this
And given that
situation.
we're not experts in energy law, that just makes me uncomfortable.
Well, I don't think this is a complicated question of energy law, at least the primary submission we're making today, Your Honor. We think it's more of a straightforward scientific or engineering or even a common sense
We
proposition.
also aren't experts in engineering.
Well, fair enough, but just say common sense. If we want to test for a variable, if we change two things, we don't know which of the two things, if we need a control group, and then we add an experimental group, you want the control group to be identical in every respect except for the one variable you're changing. In this situation, the one variable you're testing is what is Page Ranch causing to the grid? And that's not what they do. To be very clear, what they do is they start with a base case. The base case is derived from the regional transmission planning process. That's just looking at what happens in a particular time. Say 2021 was the base case for our cluster. What they did was that they took that and then they made various adjustments to it because according to Southwest, the grid is constantly changing. That's on Southwest Brief 23 and JA 323. They say they make a bunch of adjustments
I
to.
thought the adjustments were just everybody who was ahead of you in the queue. No.
They also do that. That's what I'm getting to. So they start with the regional transmission process, then they make adjustments. That's Southwest Brief 23 and JA 323. Then they add all the higher Q generators. Then they add us. Then they test for contingencies. Then they do things like say, well, what happens if we catastrophically lose a transmission line? What happens to the grid then? And then what happens in the middle of summer if we do that, in the middle of winter if we do that? That's when they run those tests. And then they say, oh, look, the grid failed. But they don't know, and they expressly admit they have no idea if that same problem would have occurred immediately
In the
before we were
pre-transfer,
added,
yeah.
or in the base case, or even, I mean, we
We're
think,
saying that the problem could arise in the pre-transfer scenario and not necessarily in the third scenario.
absolutely, we think it could arise in the pre-transfer scenario. We think it could arise in the base case. And we think there's evidence even in the regional transmission process, but I don't think you need to even reach that because I think the flaw is more fundamental. It's simply, if you're going to test for but-for causation, you actually have to test for but-for causation. You can't just look at the grid at a particular snapshot in time, run a bunch of contingencies and say, well, we're going to put all the costs on your client. I'm happy to answer additional questions on that point or any others, or I can save the balance of my time for.
What do you understand to be the relationship between the regulatory standard of but-for causation and the statutory gloss principle of cost causation? Are they the same? Are they different?
I want to make sure I understand your question properly.
But-for cause versus cost causation.
I think what this court has said is that they are the same. I'm sorry, not the same, but they're closely related. And essentially cost causation requires at least a rough approximation of the costs that in this context, the cost that your connection required. And it also, but it's not purely but for, because it also requires looking at the benefits derived. I think that's the distinction the case law bears out. So there's both a burden and a benefit inquiry. But again, I think the key fact here is that you actually need to be able to test for that incremental impact of your generation. If this was a case where they had actually performed the proper testing and we were assigned some costs, we could not come in here and quibble about, well, it should have been a tiny bit higher, a tiny bit lower. They just need to know, but here they just don't know. Were those problems already in the grid before we were added, or was it our addition? And perhaps it would have been if they performed the tests as Mid-Continent does, but they have not done so.
I had thought cost causation was the more intuitively simple argument for you. You're pushing but for cause hard. And I understand that, but I'm a little wary, like Judge Pan, of trying to tell the agency how to structure the studies. The cost causation just seems like there's this basic idea, even if you were the but for cause of a bunch of expenses, right? If the benefits are diffuse, they have to at least take a look at that in allocating.
I absolutely agree, Your Honor, and I think that's another way for the court to rule in our favor. They didn't look at the benefits at all. And I think it's especially striking here because, again, the regional transmission line along the eastern border of New Mexico that they assigned to us as part of the preliminary cost assignments, once that was actually added to the models later on in the process, it dramatically reduced the cost to a fraction of what they were before. So clearly there were regional benefits to the cost that they were.
It's a high voltage line, right?
Correct.
Which has regional benefits.
Regional benefits, exactly. That's the Old Dominion case. So yeah, so I certainly don't mean to push that we need a ruling on but-for causation. I think you could look at it through, I think but-for causation is just intuitive because that's really cause and fact. And they just don't know if we were the cause and fact. And in fact, they've absolutely admitted, again, JH 321 never claimed that the non-convergences weren't already there. And I think the other striking quotation I'd urge you to look at is JA 325, when Southwest, again, in his answer says, quote, "The fact that a contingency causes non-convergence in the pre-transfer case does not mean upgrades cannot be assigned to mitigate constraints." So they say, even if there were non-convergences in the pre-transfer case, and we don't know whether there were or not, that doesn't mean we can't assign the cost to you. And again, that just seems very much a basic cost causation flaw.
Okay.
Thank you. Thank you, rebuttal. Who's next? Ms. Gow, whenever you're ready.
Angela Gow for the Commission. I want to start with Judge Pan's point about standing. I think that's an excellent point here. You know, the supposed injury of losing their original queue position, that was caused, as you say, by their voluntary decision not to pay their study deposit. It's if anything, self-inflicted. And the other point that Judge Pan raised on redressability, I also want to explore that because not only is this a voluntary business decision, but time has moved on since the original phase 2 study of Cage Ranch's cluster. It's been years now. And from what I understand from Southwest, their cluster study is done. The other generators that chose to pay their deposits and stay in the cluster, their studies are completed. They've executed generator interconnection agreements, and they're in the process of building their network upgrades and facilities needed to interconnect. And in view of all that's changed with the passage of time, I guess I'm just really uncertain as to what could happen at this stage for Cage Ranch to obtain their desired relief of their original queue position. I'm not.
If they paid their deposit and were still in the study, could they still challenge the phase 2 study?
Yes. Yes, if they had,
That's what they should have done then. They should have paid their deposit and then brought this challenge. But if they succeeded, you still would have had to redo the study.
that's correct. If they had succeeded, we still would have had to redo the study. But your point being that the more appropriate way to approach this would have been to pay the deposit so you retain your queue position and you continue to be processed along with the rest of the queue.
And retain your standing, basically, to
Exactly.
challenge that study.
Exactly. So that you're, continue to be studied along with the rest of the cluster. At that point, there's something that could be done about refunds if they happen to be correct on the cost allocation point, et cetera. But also, I do want to note that in this case, after they withdrew from the queue, a restudy was done after the board had approved the Crossroads Roadrunner project in July 2022. And therefore, none of the generators that paid their deposits needed to, were assigned any costs associated with that project. So as to the improper cost causation challenges that Cage Ranch alleges, those costs were actually, after iterative interconnection study, not actually assigned to the generators in its cluster. And that
Does that render anything moot? Or not? Because that study is gone and passed, you've moved on, and it's a whole different set of costs. Is that mootness?
I would think that there is some mootness implicated here because the actual costs that they dispute were improper were not actually assigned to any of the generators, and the generator study is done in any case. So I'm not entirely sure, what sort of live challenge remains here. But as to standing, I believe Judge Pan is correct that there really are big questions here as to whether Cage Ranch has demonstrated there's still relief that's redressable for them.
Why are we hearing about all this for the first time now?
That's a great question. I will say personally,
We have a duty to consider this, but it's a little hard to deal with all of this on the fly at oral argument.
I take your point, Your Honor. I personally was not aware of how far the phase 2 study or the original cluster of Cage Ranch had progressed. And in preparing for this argument, learned that fact and agree with Judge Pan that with this new understanding of the circumstances, it does seem that standing is more tenuous.
So one aspect of this is whether the injury was self-inflicted. That seems like it's a legal question that goes to standing, and we have to figure that out. Another one is whether changed circumstances with new studies and such have affected our ability to give relief. So walk me through that. That might be a redressability point, but it might also be a mootness point, and it's your burden to show mootness. So just help me understand where we are in terms of these studies.
Sure. As to the voluntary decision point, the interconnection process is designed to act as a funnel. There are numerous requests that start out in the process, and as we go on with, increasing study deposits and withdrawal penalties, those projects that are less certain make the business decision to withdraw their request. And again, they enter this queue, knowing what the ex-ante rules are, how these studies are conducted, when projects are entered into the model or not. And so if they're confronted with a cost allocation that is unfavorable or that they dislike, it's their voluntary decision whether or not to put up a deposit in order to continue the process in hopes of, upon further iterative study, their cost allocations will change, or to do as Cage Ranch did here, which is withdraw. And, even today, it remains free to resubmit a new request where it could have a different cost allocation. So that is, in my view, a self-inflicted injury, if anything. But as to your point,
Just on that, does it matter how excessive the bond is or the security is?
the the security
And we
being,
have to assume the merits of their position for standing purposes. And the merits of their position is that, as I understand it, is that the flaws in the study make the deposit wildly excessive.
the security is 20% of their total assigned costs, but the system is designed that way. Given how severe the backlogs are in the interconnection queue, it's designed to pressure generators to make these business decisions earlier in the process. If they felt like the potential risk that a portion of their 60 million deposit being, under risk was not worth the cost of their project, then that's an economic decision that they've made. Other generators.
Is there a refund of the 60 million? Like the people who paid in here and then there was a restudy and it turns out the costs were lower. Did they get a refund of their deposit?
So I believe Southwest can speak to that more in more detail, but I do think there is some refund at issue here. So in tariff section 8.14 Part G, that's at JA 529. It states that when a generator has made it to the end of the interconnection process and they execute a interconnection agreement, the financial security amounts they paid are put towards the upgrades that have been assigned to them and towards the construction of those upgrades. So any remaining funds that are left over will be refunded to that customer. So in this circumstance, if generators were initially assigned costs associated with an ITP project that is later approved and then added into the study at a later point in time, their financial security costs will be refunded to them in excess of what it actually costs to build their necessary upgrades.
So when the decision was made to withdraw or not to post the necessary deposit, had the plant been under construction at that point?
When
Or the solar field, whatever it is?
When Cadence decided to withdraw, the board had at that point approved the Crossroads Roadrunner project. So it was at that point part of the regional transmission expansion plan. And because the interconnection study process is iterative, it would have been added into the next phase of study. And here, that was the October 2022 restudy. That gets to a great.
No, the question is, when in July, I think it was, they
Yes.
withdrew, right? Had they expended money on construction as of July?
No,
Okay.
no,
All right, so it's purely an ex ante risk calculation.
that's correct. Purely ex ante risk calculation. And
But they had noticed that Crossroads Roadrunner, I love that name, that Crossroads Roadrunner had been approved. So perhaps there would have been a refund on their 60 million.
that's correct. I do want to also emphasize along with that point, the interconnection process is iterative. So at the end of each phase, that's a cost estimate based on, that point in time, what Southwest believes their upgrades will amount to, but it's continuously being changed. In between different study phases, this transmission grid, which is always in flux, new developments are occurring. Those developments will be accounted for in the next phase of study. So even if, at the end of phase 2, a generator is initially assigned costs associated with an upgrade that's contemplated in the integrated transmission process, as long as that upgrade is approved before the next phase of study begins, then that will be incorporated into the study model.
And approval came in August,
It came in July 2022.
same month in which they withdrew?
They withdrew, I believe, in August. So they withdrew after approval came.
Oh,
I think it was like August 15th or something.
There is a
Was the
timeline.
draft came out with the costs and then August 29th is when you finalized the costs.
I believe that's correct. And there's a timeline in our addendum to our brief on page A3 that lays out the dates of the key events. And the,
Oh, sorry, finished. Are you-
no, that was it.
So suppose, just for the sake of argument, suppose I think the injury is not self-inflicted and they've alleged problem with this pre-transfer study is this so phase one, phase two?
Phase two.
Phase two pre-transfer study. What's happened in the interim that bears on redressability or mootness with these studies? What happened to that study? How has it been overtaken or not been overtaken by events? Just walk me through that.
Right. On the redressability point, that's key to the relief that Cage Ranch requests is the restoration of their original queue position.
Right.
But that's, from my perspective, I'm not sure how that's possible at this point because, you know, after they withdrew, time has marched on and those studies continued. Phase two went into the restudy, then it went into phase three, and then the interconnection agreements with the remaining generators were finalized. So I'm not sure that their original queue position even exists anymore.
So we've gone from phase two pre-transfer to we're all the way through phase three base pre-transfer transfer.
Yes, we're all the way through all of those studies at this point, and the remaining generators that paid their deposits have executed interconnection agreements, which is the end of the interconnection study process. So those costs are
So if
finalized.
they were still in the queue, if they were, or we talked about restoring them to the queue, they would have come to the end of the process, found they had no liability for a deposit of $60 million. No one else in the cluster had to pay as well, right? And so they would go on to an interconnection agreement, wouldn't they?
That's correct.
Yeah, there would be no further obstacle. They would simply enter into an interconnection agreement and seek its approval.
That's correct.
So that's the redress.
Well, but that's if they had stayed in the queue and had continued to have their requests studied along with everyone else's. At this point, though, the cluster under study is a different cluster, and Cage Ranch's request has not been evaluated along with the other requests.
Just stay with the cluster 5. That group was, that evaluation has been completed.
Yes.
What reason is there to think that had there been another application in cluster 5 that it would have changed the outcome?
Because Cage Ranch's request has impacts on the transmission system, and there are upgrades that are triggered in response to the impact their request has. So when they withdrew from the queue, their request and their proposed generation facility was taken out of the study. So the impacts were no longer modeled. The costs that other generators in their cluster have been assigned have been in the absence of Cage Ranch's project.
I have it. Thank you.
So it just seems to me like on mootness, they are asserting that there have been all these errors in this phase 2 study. That study actually didn't even go into what has happened now because there was a restudy and the process proceeded without them based on a restudy. And so if we were to hold that there were mistakes in that other study, there's nothing you can do about it. It just seems to be that it's moot because even if they're correct, it has no bearing on this entire process that has now proceeded because there was a restudy that went on without them. So there's nothing to correct because this whole new restudy happened.
That's correct.
That actually addresses all of their concerns because it lowered the cost by considering Crossroads Roadrunner.
Yes, that's correct.
So it just seems to me that there's also a mootness issue in terms of you may be right that there were problems with this study, but it's a study that's been overtaken by events. It's been chucked and now there's a whole new restudy. And so correcting anything that was wrong with that first study does nothing at all.
Is there any barrier to their simply petitioning again?
To resubmitting a new request?
Yeah.
No, there's no barrier. They can resubmit their new request. And, you know, given the current state of the grid, the cost of the Crossroads Roadrunner project wouldn't be allocated to them in any way.
No telling what would come out of the next study.
That's true. It's a new cluster. There's new costs and there's the time component because in that intervening time, the grid will continue to change as it always has. But I do want to, I know I'm over time, but I did want to try to address the merits if I could briefly. As to Cage Ranch's argument that there are two variables changing. The reason why the contingency analysis is only done on the transfer case is because running one on the pre-transfer case would be duplicative. Aside from the current cluster under study, everything else is already studied under contingency through a separate process. So we think about the study model in three parts. There's the current cluster, then there's the higher queued interconnection requests from prior clusters. And then there's the existing transmission system that Southwest studies annually through the integrated transmission process. Two of those three components are already subject to a contingency analysis in their own separate process. And when Southwest puts together the study model for the current cluster, the network upgrades that are assigned as a result of those other contingency analyses are incorporated into the model. So higher queued interconnection requests are assigned network upgrades in their own cluster study, and those assigned upgrades are put into the study model. Also, with the existing transmission grid, under the integrated transmission planning process, the board approves projects.
But then is the addition of this cluster group compared to that pre-transfer group that includes the upgrades? Or is it compared to the base case that does not?
It's compared to the pre-transfer case that has everything plus all the upgrades that have been assigned through the respective contingency analyses.
Then it sounds like there's just a factual error in their argument that you actually are comparing the third phase to the pre-transfer phase?
Yes, I think all of the parties in this appeal agree that the purpose of these interconnection studies is to isolate the effects of new generator interconnection requests. And that's essentially what Southwest Processes does. Even though it only does the contingency analysis on the transfer case, it's because it already does a contingency analysis on the other components of the model in their own separate processes. And
then incorporates those.
And incorporates the results into the study model. And I want to point you specifically to, for example, the tariff at 3.8 JA 509, which is also cited in our rehearing order at paragraph 28 JA 437. It says that before Southwest assigns upgrade costs to the current cluster, it will first mitigate study constraints with network upgrades that are part of the current transmission expansion plan, i.e. the upgrades that come out of the ITP process, and also network upgrades that are assigned to the prior queued interconnection requests from earlier clusters. And I also want to refer you to tariff section 8.4.1 on JA 518, which similarly talks about that process of incorporating those network upgrades. As to the timing of the Crossroads Roadrunner approval, that project was not approved until July 2022, and it's necessary for this interconnection process to have these strict cutoffs and rules because the grid is constantly in flux, constantly changing. There has to be this line that we draw that says, no more changes added to the study. We have to stop at this moment in time and just run the study. And that's exactly what the rules work out to here. It's true that, sometimes we'll see these edge cases where things will look a little more difficult, but the overall process that's guaranteed by these rules are fair. They make sure that customers can proceed through their interconnection studies without holding these studies open for, further changes. And it also respects the iterative nature of the interconnection process because changes that aren't incorporated into one phase can make it into later phases. With that, if there are no further questions.
Does FERC regard the but-for inquiry as sufficient to satisfy cost causation? See, it seems to me you've taken you, the agency, have taken some shifting positions on that over time.
Yeah, so yes, I believe the agency's position is that in the interconnection context, the commission uses but for cost causation to satisfy the cost to satisfy cost causation principles. And that stems from order number 2003, which is also cited in our brief, where the commission determined that the cost cost causation principle requires interconnection customers to initially pay the full cost of the network upgrades that would not have been needed but for their interconnection request. And here, that principle is satisfied because at the time that the phase 2 study began, the Crossroads Roadrunner project had not been approved, nor had any other project in that area. And so this study model, which is necessarily a snapshot in time, under that model, it was Cage Ranch's request that was the but-for cause of its assigned upgrades, regardless of what happened several months later after the study was already nearly complete.
Suppose the upgrade has diffuse. They are a but-for cause, but the upgrade has diffuse benefits for the grid. Do you account? How do you account for the latter?
So this is more of a policy decision from what I understand. I think it could be argued that for any interconnection upgrade, there is some diffuse benefit to that upgrade. But the commission, from what I understand, has decided that cost allocation in the interconnection context should work in the but-for causation framework, because the existing load on Southwest grid, they've already paid for, all of the facilities that exist on the grid, and new interconnection customers, they'll come in and they won't have to pay for any of those facilities. So what the commission has decided is, if it respects the cost causation principle, is to have new interconnection customers pay just those upgrades that are necessitated by their interconnection onto the grid.
My understanding of Tenaska's read on this is that in this context where there is an interconnection request, basically an operator like Cage Ranch says, let me join your grid. And the but-for causation is the cost for you joining our grid is the cost of these upgrades that we have to make in order to have you.
Yes.
Because it's but-for, that means that if you weren't asking to join our grid, we wouldn't be doing any of this stuff. And so the primary beneficiary of the upgrades is the requester, because absent the requester, there would be none of these upgrades. It's a but-for thing. And so Tenaska seems to say that it's unlikely that there would be diffuse benefits that need to be allocated to other people in this particular factual context, because the upgrades are because this operator has asked to join the grid. And so they're the primary beneficiary.
That's exactly correct. At the time that the study is done, the but-for cause is the generator that is the primary beneficiary, because these are upgrades that would not have been needed but for their request, and they benefit by being able to interconnect reliably to the grid. And on that point, I just want to make a final note, which is, the interconnection grid, there can be concerns identified on the grid that Southwest monitors over years, but for cost causation, there needs to be a tipping point that's reached before an actual upgrade is needed. And whoever is responsible for reaching that tipping point is who pays for the upgrade. That's the system that the commission has adopted for the interconnection generator context. If there are no further questions.
I'll just point out that the company cites 2 cases allegedly to the contrary about system benefits, but neither of them is an interconnection case.
That's correct. None of those cases are in the interconnection context, which the commission has decided to use a very different cost causation policy.
Thank you.
Thank you.
Burnett.
Good morning. Thank you, Your Honor. May it please the court, Matt Bennett for Southwest Power Pool. I'd like to begin with this whole but-for cost causation issue. There's a couple things that I think need to be pointed out. One is but-for is sort of a way to implement the cost causation principle. And what it does is it limits the responsibility of the generator to pay only for the upgrades that they are directly causing. So they don't pay anything for the existing grid. They don't pay anything for new upgrades that arise out of the integrated transmission plan, which is SPP's regional planning process. They only pay for those incremental upgrades that were identified by SPP as necessary to connect their generator to the grid. I'd also like to point out that the project that was actually assigned preliminarily to Cage Ranch is a different project serving different needs than the project that was approved through the regional planning process. So the way SPP looks at generator interconnection, we look at years 2 and 5 in the study. The integrated transmission process looks out 10 years. The reliability needs, if you look at the integrated transmission plan, which is in the record, the reliability need for the Crossroads Roadrunner project doesn't arise until 2031. The reliability need that is caused by the addition of the Group 5 projects in the Phase 2 study actually arises in 2026. The reason the project was approved as part of the 2021 ITP to be part of the SPP transmission plan in 2022 is because that particular project, the Crossroads Roadrunner project, also provided additional economic benefits. So when we're looking at a project, we're looking at multiple things. Is it fixing a reliability problem? Can it provide economic benefits? Is there a public policy reason for including that project? This particular project was approved earlier than it probably would have been if we were just looking at reliability because it provided additional economic benefits. Those are not benefits that they are paying for. Those are not needs per se. They're called needs in the planning process, but it's really, does it provide a benefit? So the idea that these were the same projects is just not true because what we assigned to them was a more limited project to address a reliability need caused by their group during the 2026, I think it was summer. So it's 2 different projects. I'd next like to talk a little bit about the.
Why does interconnection matter to justify a very different approach to cost causation? If we were not in interconnection, right, and I'm not an expert either, but I have Old Dominion in mind, which I just remember.
Right.
One utility in the grid wants to do this upgrade. It's a high voltage line. It has regional benefits and the costs would be allocated throughout the grid and passed on to generators or customers or whoever, because high voltage lines have regional benefits. Why does that principle vanish in the interconnection context?
Because FERC has asked us to only assess cost to generators that are caused by the needs that they create on the system. So yes, while as a general proposition, a 345 kilovolt line could have broad regional benefits, it doesn't mean it always does. If it's causing if they're causing a problem.
It might or might not.
It might or might not.
That's the cost causation question you would normally look at.
But there's no evidence in the record that the project that was actually assigned to them, which was the Crossroads to Eddy project, has regional benefit. It was never assessed for a regional benefit. They didn't provide any evidence that it provides regional benefit. It is put in place to address an immediate reliability need caused by their interconnection. It is not looked at. It was not looked at more broadly. What happened is events overtook that project and SPP determined that there was a different project, the Crossroads to Roadrunner project, that we could justify for regional cost allocation on the basis that that project does provide diffuse benefits. It provides congestion relief.
Put aside the later studies. I need to work that through.
Sure.
In my own mind. But the reason for the decision under review is FERC's legal position that but for causation suffices as a matter of law to establish cost causation. Right?
For generator interconnection.
For generator interconnection.
Yes. Because when a generator seeks to interconnect to the grid, that's a voluntary choice on their part. Doesn't mean that the grid needed the power. Doesn't mean that that generator is the right generator to serve load. It just means that they want to connect to the grid and have an opportunity to participate in the market. So there's no guarantee that the upgrades that they are causing actually have regional benefit, which is, I think, why FERC segments it into interconnection versus general regional transmission planning. Because we have to have an open door that anybody who wants to determine whether they can connect, we have to at least let them into the study, tell them what it's going to cost. And I think FERC has really drawn that bright line. I think another point to make is that these are all.
It doesn't necessarily mean the upgrade will have regional benefits,
Right.
but it doesn't necessarily mean that it won't.
It doesn't, but there's no evidence in this record that that particular project does, because ultimately what was approved was a different project.
I think, can you also say that they didn't claim regional benefits?
They did not demonstrate regional benefits because
Well, did they even purport to have them?
I think they claimed in their brief, but I don't recall them claiming at FERC that this project provided broad regional benefits, and they certainly didn't put in any evidence.
No, but FERC didn't say, as a factual matter, no regional benefits, therefore just assign all of the cost on a but-for basis. They said but-for cause is all that we care about. We're not.
Well, I think it's also important to realize that when we talk about interconnection upgrades and but-for costs, they are fronting the costs, but they actually get paid back over time. That's a policy in Order 2003. I think it's paragraph 694 to 696 of Order 2003 that says, once they connect, we have to pay them back. So at the end of the day, they're not actually paying anything to interconnect.
Sorry,
Southwest.
The RTO.
Yes.
Okay.
Is that just through their approved rates?
So the way it works in an RTO context is we give them what's called congestion rights, long-term congestion rights. And then what happens is in the market, the SPP market sets a price for congestion, which is basically the difference in cost to transmit power from point A to point B. And for the upgrades that they provide to the system, we have to provide them an opportunity to get that revenue. And that's a long-term congestion right. And that's a requirement. Like I said, it goes back to Order 2003.
So it's a rate. It's in the rates that in the tariff that they file.
I'm sorry?
It's in the rates that they seek.
They being SPP or they being, yes,
SPP.
yes.
Coral Ranch.
No, it's in the SPP tariff that we will give them long-term congestion rights to reimburse them for fronting the cost of these upgrades.
Okay.
So when you look at it in the totality, generators ultimately end up not paying to connect to the grid because they're only fronting the costs, because these are costs that other members of the RTO didn't necessarily want to incur. Because if these were costs that were seen as beneficial to everybody, they would have been included in the regional plan. So that's really kind of where I come out on the cost causation but-for principle is ultimately the load is going to end up paying for everything. It's just the timing of when the money comes in. And if I could just quickly,
On this point, though,
I'm sorry.
just factually on this point, because as I was looking at this record, I was a little bit confused about it. But it seemed to me that if there had been an argument that the benefits of the Crossroads Roadrunner addition were actually being assessed in the but-for causation thing, then they would have something. Because if you were going to do that anyway, or if the system needed the Crossroads Roadrunner thing, assume it wasn't an economic thing, but a reliability thing, then they would have a claim that they were being unfairly assessed something with broad regional benefits or whatever. But it seems factually that's not the case. And instead, what they were being assessed was this Crossroads Eddy thing, which didn't benefit anybody but them. So factually, there is no diffuse benefits to what they were being charged, even though theoretically they could have had a claim if Crossroads Roadrunner were being assessed to them when it turns out Crossroads Roadrunner, it appears benefits everybody.
I think that's potentially true. My only reason for quibbling with that is when did the need for the Crossroads Roadrunner project come in? And if you're just looking at it from a reliability perspective, we don't need that project until 2031. Okay. So if they want to connect to the grid, their requested commercial operation date was December of 2023.
But does diffuse benefits depend on that, on the timing? Because it turns out that when if you were going to do it anyway, it was going to benefit a lot of people.
Well, it does depend because by 2031, the grid may look entirely different and we may no longer have that reliability need. That's why we do these studies every year, and that's why we do these studies sequentially. So there's a possibility that by the time that project was needed for reliability, it's no longer needed for reliability. But I will say in this situation, there was also the economic benefit, which is what justified it being approved earlier. And in that situation, I would agree. If we were to say you have to pay for Crossroads Roadrunner, we would be actually violating our tariff because once a project is approved in the regional plan, we remove it from the interconnection process. When I say we remove it, what I mean is.
But what if you know you're going to approve Crossroads Roadrunner, but at the moment in time in which you're issuing phase 2 interconnection study, it hasn't been approved yet? Do you take that into account, or are you supposed to?
No, we don't take it into account until it's actually approved by the board of directors.
Okay.
And that does get to.
But everybody participating knows that it's possibly going to be approved. So everybody knows that that's a possibility.
Well, everyone knows it's being considered. If you look at the joint appendix, there was actually a dispute as to whether this project had the needs that SPP had indicated that it had. I believe I don't have the site in front of me. It's a JA 174-5, where it basically notes that there were members of the transmission working group, which is one of the underlying stakeholder groups that disputed whether this project was needed. So while yes, it was
Roadrunner?
That was Crossroads Phantom, which is a whole other project. That's where we kind of get, you kind of have to draw a flow chart to figure all this out. I understand, but that was Crossroads Phantom, which was sort of the predecessor, if you will, to what ended up being Crossroads Roadrunner, which is a different project than again from Crossroads Phantom. So, but the tariff is also designed to protect generators from additional costs because once a project is part of SPP's regional plan, they no longer pay for it. It's factored into their studies, and that's what happened here, as Ms. Gow pointed out, is when we did the restudy on phase 2, which we had to do because among other generators, cage ranch dropped out. We have to do a restudy when people drop out of the queue because that's going to change the dynamics of everything. That's going to change their demand on the system. That's going to change power flows and everything. That project effectively relieved some of the issues that were being caused by that group. So by withdrawing from the process prematurely, they did not benefit from having that project from which they would benefit but would not pay to be considered as part of the cost that they are assessed. If I could, I know I'm well over time, but I just want to talk just briefly on the redressability issue. Just the 2017 cluster's done. Studies are done. Interconnection agreements are signed. People are building. Transmission owners are building upgrades. I don't see how it's possible to reinsert them into that. Not only that, 2018, 2019, 2020, and 2021 are done. 2022 and 2023 are past phase 2, which is the phase where they dropped out. So I don't see how you can possibly redress their grievance by restoring a queue position that just simply does not exist.
There's no queue anymore.
There's no queue anymore.
That,
right.
So I guess it's a question for your friend on the other side, but I hope that they try to get into a cluster group in the meantime. It didn't wait for this whole process to play out before doing that. Do you know whether they've tried to get into another cluster group?
I don't know if they've tried to. Typically, until studies are done, SPP treats who's going into the study confidentially as for business reasons to protect the generator. So I don't know if they've tried. I know that their next opportunity will be to enter in 2026 to be studied. And the grid is obviously very different than it was in 2017 when they first entered their request. So.
Thank you.
Thank you.
Thank you, Your Honor. I'll try to make a few brief points. I'll begin with standing. I understand this court has to assure itself of its own jurisdiction, of course, but I do think it's telling that FERC has never raised any of these arguments until oral argument. Obviously, that puts us in a position where we are trying to do this on the fly. If you look at page 23 of our brief, we asserted very clearly that we have clear harms from having to pay $60 million in at-risk security that we would forfeit if they didn't fix the study in which we had identified very clear problems, and those harms would be redressed by a favorable ruling from this court, which would restore Cage Ranch to its queue position. FERC did not dispute that.
There's no queue anymore.
There is still a queue, Your Honor. The study process has been complete, but the queue can be reopened at any time. In fact, in the Tenaska case, that is exactly what happened. The study process had been completed, and construction was actually already underway. A generation interconnection agreement by Tenaska had already been signed. The queue was reopened, a restudy occurred, and they were assigned additional costs. That's why they came to court. So it's not the case that this is unreviewable.
Has
And
your
again,
client tried to enter other clusters in the meantime?
it has not, because it doesn't need to, Your Honor. It should be in this cluster. This was the cluster it should have been in until it was kicked out by
But
being.
what if you lose?
Then it's lost its opportunity, but that was the risk it was willing to take. And I think that goes to the risk point you were talking about earlier, where it's a meaningful step in the process. And that's why we were injured. We were being asked to pay $60 million that made the project uneconomical at that time. And so we took a risk. We said, we're either going to win this case and we get back to our queue,
But
which
you
is.
recoup your 60 million.
Well, Southwest has said that multiple times. They don't cite anything in the brief for that. I've talked to my FERC colleagues and that's not the case as far as I understand it. We don't believe we get reimbursed those costs. So I'm not really even sure what they're referring to. I'm not sure how you would resolve that on this record, considering they don't cite anything for that proposition. So I don't actually think that's the case. This is money, $60 million that made the project uneconomical for us.
The FERC decision refers to it more than once as reimbursable.
It refers to that, Your Honor, but again, again, it hasn't really been briefed in this case. I'm not really even sure what that refers to. So they say maybe reimbursable through rates over
I
time.
think that's at the very least what it means.
Right. But I don't know if that is some formal process or simply, we get paid back by our normal, rate making process. But again, that's, it's a different use of reimbursable, I would think, considering we're being asked to pay $60 million.
I guess there's a real reason for that $60 million. It's a lot of money, but it seems, just as I sit here listening to the arguments today, that it's important for FERC or Southwest to understand who's in and who's out, because all the decisions are made based on who's in and who's out. Then they decide, what upgrades they need. Then they decide how to allocate the different costs of these upgrades and all of these things. So it seems that a company in the position of your client needs to pay their 60 million, stay in, keep your appeal of the study intact. And then if you win, at least you're in and all the subsequent stuff accounts for your draw on the grid. But then it's just a question of money and figuring out what they owe you. So it just seems like an untenable process that you're proposing, which is that you can just refuse to be in, don't pay your deposit, and then come in later when it's just really difficult to get you back in. But if you had stayed in, you would have either gotten a refund or
we would have been.
turned out to work out for you in the restudy, or we could be at this point, you could have entered a contract and be building your thing and you'd get some kind of a refund. But now it's just really hard.
Well, Your Honor, or we would be, I think there's a third possibility you're not considering, which is that we would be saddled with paying $60 million in an uneconomical
No,
project
but
for
your
us.
60 million always gets credited to what you pay later.
That's, if we were asked to pay 300 million, but we owed a tiny fraction.
No, but if it turns out at the end of this process, you're asked to pay 20 million, you would get a refund of 40 million.
Correct. But if the process had completed and they said, actually, you owe 100 million, then we would have had to pay even more for an uneconomical.
That's just part of being part of this process, which sounds like it's very dynamic.
But it sounds like we can't really then meaningfully challenge legal errors if we're being asked to put at-risk security that is forfeitable completely.
But it just seems that there's a real reason for that, because they need to know who's in order to do all this planning. And it's not just you, there's like all these other people in the cluster. So for you to say, well, I'm not going to pay my deposit, and now late in the game, I should be able to come back into the queue, scramble this whole process, put everybody back to phase 2 when they've completed the process, just because you didn't want to pay your 60 million.
Well, rather than speaking
Like an
hypotheticals.
appropriate way to proceed.
Rather than speaking hypotheticals, Your Honor, I'll point you to JA 351, footnote 43. We cite half a dozen cases there For example, Florida Municipal Power Agency, 167 FERC 61 138, acknowledging that reinstatement of queue position and reordering of queue appropriate remedy for remedying unjust, unreasonable, or unlawful practices. We cite Edison Mission Energy. We grant Edison Mission's complaint and direct MISO to reinstate the queue position of any Group 5 interconnection customers. The list goes on. I'm just saying, I take the points you're making hypothetically, but the fact is FERC does this all the time. This is not an uncommon situation. And in fact, we said in our opening brief on page 23, these harms are redressable. They can restore the queue position. FERC did not contest that in its
So it
brief.
seems to me that they could move mountains to accommodate what you're asking for, but I don't know why they should have to when you could have just paid your deposit.
Well, that's just the way that FERC practice works, Your Honor. It's the way the tariff itself contemplates. It says if you've been withdrawn from the
But if
queue,
you know
that's
that this
section
is how
3.7.
FERC practice works, you know that you're taking a risk by not paying your deposit.
But we don't
Because
think
letting
that's,
you back in the queue is ultimately discretionary and based on 4 factors, which you already conceded.
well, again,
So you might fail on the 4 factors.
no, I don't think so, Your Honor, because the tariff itself contemplates a restoration. It has nothing to do with those factors. That's
No, but
tariff
it's
section
still
3.7.
discretionary. You don't have to be restored to the queue, right?
I think
Even
there's
if
two
you
separate
concede,
issues.
they
One is
still
whether
have this-
we should have gotten a waiver, and a second is whether this court has remedial authority through vacating the orders. But again, rather than speak in hypotheticals, I urge you to look at those cases. I would also suggest, Your Honor, especially given that mootness is their burden, at a bare minimum, if we're going to resolve the case on this ground, which was not raised by them at any point, the court should ask for supplemental briefing or even now, I'm happy to offer it if you'd like to see something on this. I just think that would be an unjust way to end this case, considering they had ample opportunity to say there was no remedial authority and didn't do so. Another quick point, I just wanted to push back on FERC's point that somehow these had already been studied. They do not use the transfer case from the 001 cluster to test the 002 cluster. We know that because they use different studies. Page 8 of our reply brief, we point out that they start with a different baseline model, 2021 model for our cluster, 2019 for the prior cluster. So there's just no basis to say that the testing has been complete. Finally, on the system-wide benefits point, Your Honor, I do think that's a critical point. These are high voltage lines that have system-wide benefits. If you look at page 14 of our brief, we have a map. And if you look closely, you kind of need a magnifying glass, but if you look closely, you can see the different grid, the areas where this transmission line is going to be built. So all of the projects we've been referring to today, the Crossroads Eddy project, the Crossroads Phantom project, the Crossroads Roadrunner project, they're all obviously involving Crossroads, right? It's all the same area of the grid, but just different. The transmission process is trying to figure out where exactly are we going to put that? Are we going to connect 3 lines? Are we going to connect this way, or this way, and this way? So it's true that at that time of the transmission process in February, they had not approved the specific project they ultimately approved. But what they had said was that it was a multifaceted problem in that region. That's JA 218, JA 235. The area experiences thermal overloads and insufficient voltage support leading to voltage collapse. So this, I think, goes exactly to Judge Katsas, your point, that if you are going to have a rule that says cost causation is but for causation only, then you really do need to test but for causation. You cannot then assign costs based on grid problems that pre-existed our connection. If you're going to take a broader view of cost causation and say it incorporates both but for causation as well as benefits, well, then maybe you have a little more flexibility there. And I think, again, Old Dominion is critical on that point because that shows that these were really regional costs and problems that should be fixed regionally. Thank you.
Okay, thank you very much.
Thank you.
Case is submitted.
Council Jones, Council Jones, 30 days, another 30 days.